Welcome to the second instalment of Outer Temple Chambers Travel Talks episode on expert evidence in cross-border matters with a particular focus on instruction. I'm pleased again to be joined by Cheryl Palmer-Hughes, who, as I'm sure everyone watching will know, is a partner in Irwin Mitchell's International Serious Injury Department based in Manchester. And we previously focused on selecting experts and the factors that we take into account when choosing the best expert for a case. However, we've got to consider how the expert evidence fits into case management and cost budgeting, which are very real concerns as soon as cases get allocated to the multi-track. So, Cheryl, once you've chosen the right expert and you feel comfortable with them, what are the first things that you will go through with an expert to get them on board with what the expectations are of them when acting as an expert?
In terms of explaining to an individual what it is that you will be asking of them, I do think it's important in the very early conversations that you have with them, an explanation of Part 35, what that involves, directing them to the wording of it, what it is that they'll be asked to give evidence on. I think it almost sounds like it goes without saying, but it's important to be very specific about the area that you want them to give expert evidence on. I think one of the absolutely crucial steps that a solicitor can take is to identify your expert as early as you can, as soon as you can in the case. That gives you the time to explore what it is that you need from your expert, make sure that you're all understanding what it is that the court will require. And what I tend to do is, when I have these conversations with an expert, is to outline the likely timetable. Obviously, you can't be specific, but I think you can include specific crunch points where you might be working towards a limitation date. And then what happens after that in terms of reports and then joint reports and giving evidence at trial. Because I think we often get carried away in talking about the almost not the academic points because they're very practical for our clients, but in terms of the issues that will be dealt with within the report, and spend a lot of time talking about what they are, what that evidence might look like, without pointing out to the expert actually the report that you get. As far as proceedings are concerned, that report is almost the first step in a chain of events, and I think it's really important to explain that from the outset to the expert, that he or she knows what to expect further down the line.
Will that be factors such as highlighting to them at the dates when reports will be needed, the points when, for example, joint reports may be needed, conferences, and of course that ultimately there is an expectation that if the matter does go to trial, they may have to give evidence at trial as well.
Exactly. You don't want that fact that they might have to appear in an English court, be that in person or by video. You don't want that to be a surprise to them. You know, maybe a year down the line, by the point, you know, if you're contacting them at the outset, it might be a year, it could be a couple of years before you actually issue proceedings, and then another 18 months, 2 years after that before they appear in court. You don't want that to be a surprise to them. You don't want them to think that all of the hard work that they do in the initial 6-month period is the sum total of what you're expecting of them. It's an entire case-long involvement that you want from them. I think it's really important to set that out from the outset so that they are then able to focus on their reporting, the purpose of the report, again, without getting too carried away with the academia of what it is that you're talking about, focusing on what this report will be used for, who will see it. And I think the point about joint reports as well is an important one. Depending on what expert you are using, what countries they have experience of, they might not be familiar with both parties obtaining the report each. A lot of courts and foreign jurisdictions, they appoint a court-appointed expert, and there's just the one. And so they might not have this adversarial approach where you can each have a report, and then they are expected to discuss and agree on some issues or outline what they disagree upon. So I think that approach is important to make that clear as well.
I suppose it's also important that the experts understand what their role is in terms of discussing the case with maybe the other side's expert on when it's appropriate to do that. But also, it's important that they understand that they're there to advise the court. They're not there to, for example, help get evidence and things like that. So that will take us on to the issue of the distinction between expert and agent. How do you approach that, or how do you see that distinction?
It's sometimes practically difficult to manage because you will want to speak to somebody who might be able to give you an initial view as to the prospects of your case succeeding. And in that consideration, they may well need to go and we often see a need for records locally, and sometimes that actually involves a local procedure. My view is that the minute that somebody is actually given a power of attorney by a client, for example, that's often what is required to access medical records, police records, local records. They're actually acting on behalf of the claimants at that point. And I think it will be potentially very difficult for them to say further down the line that they are objective and that they aren't partisan. While experts often want to do everything they can to help our clients, and that's greatly appreciated, it is important to have that professional distinction and to avoid any actions being taken locally that are on behalf of the claimant by somebody who's going to carry out a Part 35 report. And so what we often do is we will speak to somebody who's very responsive locally to help us obtain initial evidence. And then we will actually send separate instructions to somebody who's going to prepare a Part 35 report. And all of this is not questioning the credibility of the people that we're instructing or liaising with as agents. It's to avoid the arguments, to avoid our opponent saying, oh, but they had a power of attorney, they were representing the claimant at that point, and now you're saying that they're completely objective. It's all about avoiding that argument rather than to question the credibility of the people we're instructing.
But it also seems to me that when we're considering costs, and we'll move on to how you might explain costs aspects to an expert and perhaps to an agent, is there needs to be a clear narrative to the court at the cost budgeting stage as to why there is a distinction between having, from what a court might see, two Spanish lawyers involved in a case, and why that's necessary, and why there is a distinction between the two. So it must be that when, for example, particularly in a lower value multi-track case or even a fast track case, making that distinction to the court clear as to why the two are needed, and why, for example, using an expert as an agent could possibly cause more problems in the long run. Do you agree with that? That must be an important narrative to communicate.
Absolutely. It's really important that everybody's clear on that your agent, your expert, your client, the court, your opponent, it's got to be crystal clear, because I've seen budgets that have come from other parties, and I can see two lawyers in there with no distinction between the two. I ask the question, and I think a lot of the advice that we're talking about, it is about from the outset being clear about what expectations we have and how the land will lie as the litigation progresses.
Keeping on the theme of costs, given that we do have an unusual system in England where we, for multi-track cases, which is the majority of the work that we do, we are looking and projecting forward at the beginning of the case to what money should be spent on expert evidence. How do you explain that process to the foreign-based experts and ensuring that they perhaps keep within those budgets?
Again, I think it's having a candid conversation. Even with experienced experts, it's important because sometimes the English system changed. It feels recent, but it was 7 years ago now. But it's important to don't assume that your expert is fully aware of what the current English system is. One of the hurdles to overcome is the difference in how we recover our costs. And one particular point to note when speaking with experts is that experts often aren't accustomed to, say, working on an hourly rate. Often it's only after the event that experts are able to tell you how much they've incurred by way of costs, and having that conversation again, from the outset, before they even embark upon the work, you need to tell them that actually I'm going to have to give an estimate to the court about how much this evidence is going to cost. And we need to be able to justify it. It's not enough just to give a figure to the court. You've got to say, well, it's at this level because there'll be X number of hours doing this. There might be some travel if there's a site visit involved. There'll be expenses attached to that. And we need to be able to be at a position at CCMC to explain how those costs build up, because from looking at figures alone, especially if we've got an agent, plus an expert, plus maybe a foreign lawyer, you can see why a judge would say, well, do we need all of these things? And asking your expert from the outset to be in a position to break those costs down for you is important. And I think another important clarification is ask them to try their best to stick to it. It's going to be an estimate because they themselves aren't going to be aware of absolutely everything that's going to happen. I think crucial is to ask them to just forewarn you. If it looks like costs are going to increase, let us know there is something we can do about it proactively, but after the event it's going to be very difficult to recover those costs.
I suppose that goes to that point of ensuring you've got that narrative to the court. If you've had that clear discussion with the expert and they say, for example, look, I'm happy speaking to you in English now, but my report is going to be in Romanian, it is going to have to be translated. That's something you can factor in then, rather than getting that nice, nasty surprise 9 months later, when all of a sudden you're having to factor in the possibly translating a 20-page report from Romanian into English. How do you see and how do you explain the benefits of conferences, and how do you explain to some foreign lawyers what a barrister is and why they might get involved in the process?
Excellent question. In terms of conferences, I think the explanation in terms of how the evidence is put together, what the Part 35 process is, in terms of mutual service, exchange, and then joint reports, that all feeds into the structure that you're asking an expert to work within. One point I think is very useful to explain to experts from a practical level when it comes to a conference with a barrister is absolutely explain who this other lawyer is that's coming in on the scene, because there is not that distinction in most elsewhere in the world. But also, and it's a point that we explain to clients as well, that your barrister is there to ask some probing questions and to test the evidence. It's really important to forewarn your expert that they're not being attacked. Because if you don't tell them what's going to happen in that conference and they are asked about their evidence, they might feel, well, have you not read my report? I'm pretty sure I've written that. And so just letting them know what the purpose of the conference is and how it's going to pan out in terms of communication between the parties involved, I think it's really important they are forewarned of what that's going to look like.
I certainly find from my perspective it's useful when whoever I'm having a conference with has a clue who I am to start off with, and I've often had the response of, well, I thought you were supposed to be on my side when you're sort of getting stuck in and testing the evidence. And equally with some experts who you meet at conferences, they've met you perhaps in a social capacity and then don't actually realise that certainly our job can be to test and interrogate their evidence in the run-up to a hearing. Just looking at some more sort of specific issues focused on, I think, the two largest areas of expert evidence we have in cross-border PI cases, which are applicable law reports and local standards reports. And just thinking, not getting in too much into the detail of the contents, but just issues with regards to each one that's important to consider early on. So, for example, with law reports, the issue that jumps out to me straight away is limitation. And we've had the judgment of the High Court earlier this year in Pandia, and how important it is to understand limitation and what's involved in service. But it also strikes me that, for example, getting some early information on burden of proof, what heads of loss are recoverable, are important factors as well when you're trying to get an idea of how a case is going to be shaped moving forward. I'm just thinking, for example, in terms of burden of proof, that can be quite significant in terms of what evidence you need, isn't it?
Absolutely. If your applicable law determines that actually the burden is on your opponent, not you, that is a very different set of circumstances compared to the usual approach that we would have in cases in England, in terms of everything that at the forefront, putting your case forward. Is really important, because that will determine when you might instruct somebody. The actual strategy might be more reactive than proactive, which is different from one case to another. I think in terms of applicable law, when you refer to heads of loss, that is a really important preliminary conversation to have, because if you are in circumstances where the applicable law does not allow for the recovery of gratuitous care, there is no point getting a report about how much gratuitous care has been delivered. There is no point in drafting a witness statement on the gratuitous care front. There might well be other issues that a witness can deal with. But those preliminary conversations and those points of principle will absolutely shape your case moving forward.
Likewise, when we're approaching budgets, as we well know, there are certain legal jurisdictions which value our equivalent of general damages very differently, and there'll be tables and scales and percentages of disabilities which, when a report is passed along to a lawyer from an English expert, they just won't be able to go through that process of assessing quantum. So there's also the point where we need to know, for example, is a middleman needed, for example, a forensic expert, to effectively convert what the English experts have done into something that, for example, a French or an Italian lawyer would understand. And they're the kind of things that we can need that information for, aren't they?
Absolutely. And I think a lot of this, not just in relation to medical evidence, but a lot of it can come down to language used. And if there are specific terms that maybe require definition or might look like they mean one thing in English and another thing in another language, I think it's sensible to explore those points in principle with your foreign law expert, so that you can ask your expert if there's a specific point he or she needs to report upon. They can include that in the report there and then, because we always have to have in mind to the costs of an additional intermediary becoming involved and actually shaping the case in an efficient way, because the risk is that you end up chasing your tail and going backwards and forwards between a number of different people, no single individual being able to give the view that you need, the information you need to assess general damages, for example.
Absolutely, and I tend to find that those conversations help, particularly when I think we can very much get stuck in the lane of thinking of things from a common law point of view, when under the civil law system, we may be using the same words, but we may be meaning different things as we're going through that kind of analysis. And for local standards reports, we sort of touched on it earlier, the difference between the report from the lawyer and the technical report, but equally that can be incredibly important with regards to knowing that information straight away. And I'm thinking with a mind on directions, but also in terms of cost budgeting and being able to have that right narrative to justify why that kind of report is necessary.
Yeah. I think the example you gave earlier of somebody who is an expert in foreign law in terms of talking about the parameters in which buildings might be constructed, or regulations, customs point to specific standards, and that separation with somebody who can actually report as to what the standards actually are is crucial. And it is really important that you look at all of these on a distinct case-by-case basis, because what works for one case in one set of circumstances might not necessarily be required in another case, or it might not work at all. So you have to be very mindful in terms of what it is that your expert can give evidence on, and actually how wide that limit can go, and actually is that enough to help the court, or do you need that extra piece from somebody else, maybe in a separate report or maybe incorporated into the report from the main expert.
Absolutely, and I think that's why we need to be sensitive to the value of the case proportionality. But and it may well tie in with the penultimate topic, which I'm going to be moving on to, which is instruction of counsel, is when we're looking at what the pleadings are saying. For example, in the classic slip in a Spanish hotel, we'll have various allegations with regards to the system that should have been deployed in the implementation of that, then, for example, there may be the argument to say, well, the floor wasn't adhering to the Spanish construction code. And that's when we think about Lockheed and we think about the arguments that we need evidence to support each limb of our argument, you need somebody to be able to present that to the judge who may be thinking, well, that's not proportionate, but you may need to make the argument, well, we can't run our case without that evidence. So what factors, and I'm going to be quiet during this section, do you consider when instructing appropriate counsel or an advocate for particular hearings?
First and foremost, it comes to, very importantly, give similar consideration to the experience of the barrister and to the consideration that you give to your expert. Ian, you and I could talk about local standards and technical reports versus lawyers reporting, probably 4 or 5 different sessions and not exhaust the conversation to be had. It's really important that you're instructing somebody who understands the issues, and it all comes back to the point again about proactively presenting what it is that you need to the court at cost budgeting, case management stage, for warning your experts about what you need. The last thing you want is to get to a conference, be that pre-service of evidence, pre-trial, and for the barrister that you've instructed to themselves not understand why you've got a lawyer and an architect. It sounds very, very simple, but actually the reality is, on a practical level, a lot of the time solicitors will be obtaining these reports based on their experience and their knowledge of the practice area. And it's at a latter stage that a barrister might become involved. And you need them to be of a similar experience in terms of why it is that you need these different experts, and also to address the court on those points, because it's crucial, because these cases are complicated, they are difficult, they are not run of the mill, there's nothing about them that is run of the mill, and so you need a barrister who is sufficiently experienced to be able to explain all of that in a way that the court can digest and implement in terms of case management directions and budgets.
Certainly from my experience, one of the things I find, and it's no criticism of the bench, is a lot of judges, particularly at the district judge level, will not have familiarity with this area of law, which clearly goes into the advocate, but I think also is so important when we're talking about that narrative, when we're talking about case summaries, the way that we form directions and various other things, and giving the judge the best possible opportunity to understand what those issues are. Because as you say, the cases are so different, and making assumptions in this area of law is possibly the most dangerous thing to do. Which now brings us on to our final conclusion topic, which is you've now got to the point of being a partner in this area of law, you've developed a huge amount of experience, but if you could give a tip to your junior self or junior people entering into this area of work, what advice would you give?
It's a good question. The advice that I would give, very simply, is do not inherit experts on cases that have been transferred to you, or that you inherit in some other way. We've spent a lot of time exploring the practicalities of expert choice, why it is that that's important. And obviously, if it's somebody within your team, then I think you can have some confidence that the same steps have been taken. The reason I say this piece of advice is because I took on a case as a trainee that was transferred from another firm, and we kept the expert that was on that case, who changed his mind before trial. And in hindsight, we had assumed that exploration of expertise and qualification, responsiveness, communication, all of those key points, we'd assumed that had been carried out. It can't have been. And so my strong advice is don't simply inherit an expert, nor should you simply accept that the person that somebody else has worked with before is right for your case. Do your own research, carry out your own considerations, give yourself the confidence. Think, actually, I know my client, I know that the set of circumstances, I know what I need. Is this person going to fulfill that need?
Some very sensible and very pragmatic advice. Thank you very much, Cheryl. Well, that concludes this two-part episode on the selection and practical aspects to instruction of an expert. We will be back again soon, focusing on more detail concerning Part 35 reports themselves. Thank you very much for watching.